Good morning, students. So today we are going to take up Consumer Protection Act and liability of medical profession under the Consumer Protection Act. Now, talking about negligence, we have already covered as to what are the main ingredients for covering negligence under tort. That includes that there is a duty, there is an omission or commission of that duty that has led to injury, there is a causal link, and they are not too removed. Thus, a breach of any of these duties give rise of action of negligence as a civil wrong under tort under the medical profession. So when we talk about medical negligence, it is no way any different, but it is only that under medical cases, under medical negligence, these are the doctors who are considered to be the defendant instead of the normal parties. Doctors are considered to be the defendant in a particular case. So when we talk about medical profession, we say any kind of profession, we say that every person who enters into a learned profession undertakes to bring to the exercise of it such care and skill as become one belonging to that profession itself. A surgeon does not undertake that he will perform a cure, nor does he undertake to use the highest possible degree of skill, but he undertakes to bring a fair, reasonable, and competent degree of skill. In order to understand these observations, it is important to understand few questions that are as to when does the duty arise, what is the duty that is owed, what is one meant by reasonable care, what is the knowledge which is expected from a doctor, when does the liability arises. With respect to first question, when we talk about when does the duty arise, it is well known that a doctor owes a duty of care to his patient. This duty can either be contractual duty or a duty arising out of tort law. In some cases, however, though a doctor-patient relationship is not established, the court have imposed a duty upon the doctor. In the words of Supreme Court, every doctor at the governmental hospital or elsewhere has a professional obligation to extend his services with due expertise for protecting life. These cases are, however, clearly restricted to situations where there is danger to life of the person. Therefore, in other circumstances, the doctor does not owe a duty. The second question that comes up is what is the duty owed? Now, the duty owed by a doctor towards his patient, in the words of Supreme Court, is to bring to his task a reasonable degree of skill and knowledge and to exercise a reasonable degree of care. The doctor, in other words, does not have to adhere to the highest or sink to the lowest degree of care and competence in the light of circumstances. A doctor, therefore, does not have to ensure that every patient who comes to him is cured. He has to only ensure that he confers a reasonable degree of care and competence. So, this gives rise to another question, that is, as to what is reasonable care. Now, when we talk about reasonable degree of care and skill, that which means that the degree of care and competence that an ordinary competent member of the profession who professes to have the skill would exercise in the circumstances in question. Now, at this stage, it is necessary to note the distinction between two aspects, that is, standard of care and the degree of care. Now, when we talk about standard of care, it is a constant preposition and remains the same in all classes. It is a requirement that the conduct of doctor be reasonable and need not necessarily conform to the highest degree of care or the lowest degree of care possible. The degree of care is a variable, whereas standard of care is a constant. The degree of care is a variable and depends on various circumstances. It is used to refer to what actually amount to reasonableness in a given situation. Thus, though the same standard of care is expected from a generalist and a specialist, the degree of care would differ. In other words, both are expected to take reasonable care, but what amount to reasonable care with regard to specialist differ from what amount to reasonable care is standard for a generalist. In fact, the law expects the specialist to exercise the ordinary skill of his specialty and not of an ordinary doctor. Though the courts have accepted the need to impose a higher degree of duty on specialists, they have refused to lower it in the case of novice. So when we talk about standard of care, reasonable care, we need to see that what level of degree of care has been taken up. Standard of care remains constant, but degree of care is variable as per your position. Another question that arises is with regard to knowledge that is expected from a doctor. Should it include the latest development in the field, hence require constant updating, or is enough to follow what has been traditionally followed? Now, it has been recognized by the court that what amounts to reasonableness changes with time. The standard, as stated clearly herein, before requires that the doctor possesses reasonable knowledge. Hence, we can conclude that a doctor has to constantly update his knowledge to meet the standard expected of him. Furthermore, since only reasonable knowledge is required, it may not be necessary for him to be aware of all the developments that are taking place. So we are examining that as to when the doctors will have duty to take care. So we have until now examined that the duty of a doctor in so far as treating a patient is concerned or is diagnosing the diagnosing the ailment. So what is the duty? The duty to treat the patient, duty to diagnose the ailment. Doctors are, however, imposed with the duty to take the consent of a person, patient, before performing any act such as surgical operations, and in some cases treatment as well. That permission is required. To summarize, any act that requires contact with the patient has to be consented by the patient. A duty of care is imposed on the doctor in taking the patient consent. Naturally, a question arises as to what is this duty of care. As per various judicial pronouncement, this duty is to disclose all such information as would be relevant or necessary for the patient to make a decision. Therefore, the duty does not extend to disclosing all possible information in this regard. Furthermore, this duty does not extend to warning a patient of all the normal attendant risk of an operation. The standard of care required a doctor while obtaining consent is again that of a reasonable doctor, as in other cases. Thus, taking the consent is one of the requirements that has been taken up into consideration in order to ensure that there is reasonable care taken and that the knowledge is possessed by the doctor. Another question arises is when does the liability arise? Now, the liability of a doctor arises not when the patient has suffered any injury. You need to understand this thing, but when the injury has resulted due to the conduct of the doctor, which has fallen below that of reasonable care. In other words, the doctor is not liable for every injury suffered by a patient. The doctor will be liable for only those that are a consequence of the breach of duty. Once the existence of a duty has been established, the plaintiff still need to prove the breach of duty and its causation. In case there is no breach or the breach did not cause the damage, the doctor will not be liable. In order to show the breach of duty, the burden on the plaintiff would be to first show what is considered as reasonable under those circumstances and then that the conduct of the doctor was below that degree, not the standard but the degree of care that need to be taken up. It must be noted that it is not sufficient to prove a breach to merely show that there exists a body of opinion which goes against the practice or the conduct of doctor. With regard to causation, the court has to be held that it must be shown that all the possible reason for the injury, the breach of duty of the doctor was the most probable cause. It is because of the breach of duty that a particular injury suffered. It is not sufficient to show that the breach of duty is merely one of the probable cause. Hence, if the possible cause of an injury are negligent of a third party, an accident or a breach of duty care of the doctor, then it must be established that the breach of duty of care of doctor was the only cause for injury in order to discharge the burden of proof that lies on the plaintiff. Normally, when we talk about this, the liability arises only when the plaintiff is able to discharge the burden on him of proving negligence. However, in some cases like a swab left over the abdomen of a patient or the leg amputated instead of being put in a cast to treat the fracture, the principle of res expo loquitur will be applicable. That means things speaks for itself, as we have already discussed in previous classes. In that such cases, this principle will come into play. Then it becomes necessary that the following conditions should also be applicable in order to prove this principle. So these principles are, first of all, that there was a complete control that was there with the doctor, and that it is the general experience of mankind that the accident in question does not happen without negligence. This principle is often misunderstood as a rule of evidence, which it is not. It is a principle in the law of tort. When this principle is applied, the burden is on the doctor, the defendant, to explain how the incident would have occurred without negligence. In the absence of any such explanation, the liability of the doctor arises. So, thus, in such cases where the principle need to be is there, nothing new or beyond that needs to be proven. So normally a doctor is held liable for only his act, other than the cases where there are vicarious liability that we'll discuss in further classes. However, in some cases, a doctor can be held liable for the act of another person which injures the patient. The need for such a liability may arise when the person committing the act may not owe a duty of care at all to the patient, or that in committing the act he has not breached any duty. Right? A typical example of a case where such a situation may arise is the case of surgery. If a junior doctor is involved as a part of the team, then his duty as far as exercise of specialist skill is concerned is to seek the advice or help of a senior doctor. He will have discharged his duty once he does this, and will not be liable even if he actually commits the act which causes the injury. In such cases, it is the duty of the senior doctor to have advised him properly. If he did not do so, then he would be the one responsible for the injury caused to the patient, though he did not has also even committed the act. So, in certain cases where the injury, the damage is to such an extent where it can easily be established that it would not have occurred without the negligence of the doctor, then only the doctors are held liable in such cases under the principle of res expo loquitur. Thus, when we talk about as to the duty to take care, we say that what all the duty of care in deciding whether to undertake the case or not, duty of care in deciding what treatment is to be given, duty to administer the treatment, duty to take the consent. There are certain aspects that has been taken up by the court in different cases, that where medical professionals can be held liable, in what cases they cannot be held liable. So thus, when we talk about these aspects, there are few cases where we can say that the medical profession is people belonging to medical profession will not be liable. Now, a doctor is not necessarily liable in all cases, as already stated, where a patient has suffered an injury, right? This may either be due to the fact that he has a valid defense, or that he has not breached the duty of care. Error of judgment can either be a mere error of judgment or error of judgment due to negligence. Only in the former case it has been recognized by the court as not being a breach of duty of care to take care. It can be described as a recognition in law of human fallibility in all spheres of life. Right? A mere error of judgment occurs when a doctor makes a decision that turns out to be wrong. It is a situation in which only in retrospect can we say that there was an error. At the time when the decision was taken, it did not seem to be wrong. So that is what is error of judgment. But if, however, due consideration of all the factor was not taken into consideration, then it would amount to an error of judgment due to negligence. So it is also important to understand the difference between error of judgment and error of judgment due to negligence. In next class, we'll try to understand these position with the help of examples. We shall continue with this topic in the next class. Thank you.